This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, and credible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation. Your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Welcome to today's Trial Lawyer Nation. Today I am joined by attorney Lee Hunt out of Santa Fe, New Mexico. Lee's a good friend, and he also just got a $66.6 million verdict on a case there in Santa Fe. He's agreed to come on and tell us about the case and how he got it. But before we start up, I just want to, as always, say thank you to LawPods. LawPods is kind enough to produce this podcast for us. They make it so easy for me. All I have to do is sit here and ask questions and talk. They do all the production, all the editing, making all the clips you might see on social media. So if you want to do a podcast, reach out to LawPods. They do a great job. Lee, how are you doing today?
Doing well, Michael. Appreciate you having me on the podcast.
Well, thank you so much for coming on. So that was an incredible verdict you got.
Thank you. It was such a rewarding experience because James Razzo was the plaintiff, and sometimes things just work out, and this was one of those cases where it did.
So tell us a little bit about the case.
So James is from California. He has spent the last 15 years as a camera crane operator. So basically they have these ATVs where they put a crane on top of it, and then they drive those to remote locations to do filming for movies. And so he was filming Only the Brave, which was a movie about firefighters out of Arizona that got caught in a wildfire. The movie was being filmed in Los Alamos, New Mexico. And so he had come out to do that. And basically when he showed up on set, they didn't have everything ready for him, kind of rushed him up the mountain and really put him in a terrible position. And as he was driving the crane, it flipped over and landed on top of him.
Who was they?
The movie production company. So Black Label Media was the name of the production company, and they also formed a subsidiary company, No Exit Film. So they were the two defendants that, from our perspective, were in charge of making sure the worksite was safe, making sure that he was taken care of, and that he wasn't put in dangerous positions, which they really failed to do.
And what happened to him?
Well, he, when the crane fell on top of him, it really crushed most of his body. It crushed his pelvis, broke all kinds of bones, internal injuries, and some really significant spinal cord damage. He was not paralyzed, but the injury was such that, walking became difficult, sensation became difficult, really just functioning on a daily basis has been a struggle for James ever since this happened.
So was he an employee of any of these companies?
So that was a big fight in the case. And I'm sure, a lot of folks kind of, all right, wait a second, how do we workers' comp and how do we deal with that and all those kinds of issues? The movie companies really have a unique way of operating. So he was not a direct employee of either Black Label Media, the production company, or No Exit, the subsidiary that they created. He was employed by a third party. Casting Crew was the name of the company. And the other thing that he was unique because he wasn't on the set the whole time. So he was a crane operator. And so he brought the crane with him from California. He was going to operate the crane for 4 or 5 days. And then when they were done with the crane, he was going to take the crane back to California. So our position from beginning to end, and ultimately this was a jury question, was that he was independent of the movie production company, which meant they did not get the protections of the Work Comp Act. So we really tried to use his independent status with the crane company as a way of showing how he was not part of the movie outfit. And that was something we fought at the motion to dismiss stage, at the summary judgment stage, and ultimately what the judge decided under New Mexico law was that control of him was a question for the jury. So one of the things they had to answer, in addition to negligence, causation, and damages, was James Razzo an employee of the defendant, yes or no?
It's always interesting how, for tax purposes, they want someone to be an independent contractor and pay them through a different company. And probably for paying workers' compensation premiums, he was not counted as one of their employees. But yet, when he gets hurt, they suddenly want to put him under their umbrella and get out of liability.
No, that's exactly what it is. I mean, they have so many different companies that they set up for all these liability purposes, but for all intents, he was not their employee in every way that they handled it, including, and I think this is a huge issue for the jury. At the end of this, so James gets hurt horribly. He's in the ICU for a whole bunch of days. They fly his wife out to stay with him. They put her up in a hotel, and within 2 or 3 months after this, they sent a bill to the crane company asking for reimbursement for paying for his wife's hotel room while he's in the hospital. And yet they want to say he's, and they were basically saying, he's your guy. You sent him out here. You put him in this position. You need to pay for this. And then they asked the jury to say that he was their employee. And that, once that letter came out, I mean, you could almost just feel the jury's ire towards the defendants, like, you've got to be kidding me. You tried to save $5,000 and now you want us to find he's your employee. No chance.
And so if he wasn't their employee, what was their responsibility they owed him?
Yeah, the responsibility was that when he showed, I mean, think of it more as a just job site. Take movies out of it. It's a job site, and when somebody that's independent, who they're bringing in for a specific purpose, and they say, our work site is over here. In this case, the work site was at the top of the mountain. And so what they have an obligation to do is provide a safe way for the person they're bringing on the job site to get from base camp, the parking lot, to the actual work site. And that's what they failed to do. And so really we tried to broaden it, not make this necessarily about movie set safety, but make it about workplace safety. Make it about something everybody's going to understand, which is, as a job site operator, you've got to get people to the job site in a safe way. And so the route that he had to take on if you think about it, it's a 3,000-pound crane mounted on an ATV base. So it's it's intended to go off-road, but not up and down mountains. And so they didn't really tell him beforehand, you're going to have to drive this thing almost 2 miles up a ski mountain, because the filming location was really at the top of a ski mountain. And the route that they provided had not been scouted. James asked for the opportunity to preview the route. They told him, no, we don't have time to do that. And when he got most of the way up to the top of the mountain, there were 2 different ways to go. And one of the local guys got on the radio and was telling everybody, hey, make sure he goes to the right. It's safer. It's not as dangerous. It's not as steep. Send him that way. The head guy on the set said, get off my radio. Go the way I told you. Go straight. Get up here now.
Wow.
And so it's really, and that came in unrefuted. I mean, nobody denied that. They just kind of said, well, James was the professional. He should have known better. He should have said no. And it was such a classic. So, our position was they had an obligation to provide a safe route, and they knew how to do it. They didn't send the actors and actresses, they sent them up the safe way. Somebody knew that they were supposed to go that way. But when you're talking about the guy at the bottom of the totem pole who's driving a crane, who just shows up on Monday morning, nobody was there to guide him up the safe way. That was a huge part of it. And the other part of it that really came through during the case was the rush that was on that morning. And I think that was, certainly from kind of stereotypical movie sets. Everything's always go, 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 fast, fast, fast. We got to go. We got to get the shot. Everything's about getting the shot. So if the light's good, and it happened to be that this morning, the first day of shooting, the lighting was really, really good. So they wanted to use the camera for the first shot of the day. But that was not the plan before that morning. So all of a sudden, James shows up and everything has changed. And now it's you've got to get up here and you got to get up to the top of the set and you got to do it right now. And that was also something that I think from a jury standpoint, everybody understands that. Everybody's had a boss that puts incredible pressure on them to get something done. And the entire defense of the case from start to finish was James was the professional. He was the only one on set allowed to operate the crane, and he should have known what the crane was and was not capable of. So when he got to the base of the mountain and saw that he was supposed to go up the route that was steep, he should have said no. And I think what countered that from the jury's perspective was really a couple of things. One was that the time pressure that was on him. And everybody, all the experts, even a lot of the defendant's witnesses all said time pressure makes people do things they wouldn't otherwise do. It takes away your ability to really take your time, look at options, make the best decision because you're trying to do the best job you can and everybody's telling you do it now. So, once that came through during the case, I think the jury was very much less inclined to blame James for going up the steep way when basically they're saying he wasn't given a choice. He was given the choice of either shut the movie set down on day one as the brand new guy or do what you're told and try to get the job done, which is essentially what he tried to do, and it just with terrible, terrible consequences.
I've noticed you said a couple points. One is that you wanted to make it more about workplace safety rather than about movie set safety. And then you talked about, jurors would understand everyone's been rushed. Why was that important to make it more general instead of making it movie set specific?
I think it was important because you want the jurors to relate to it a little bit more. We didn't have any jurors that had worked on a movie set. I mean, there's lots of movie stuff that goes on in New Mexico. So I think most everybody probably knew somebody that had been on a movie set or had talked to someone. But I think in general, when we broaden out the case, broaden the case in such a way that now the jury can relate to it. It's not a foreign idea of, well, geez, I've never worked on a movie set, so I don't know how it goes on a movie set. No, but you've been rushed by a boss. We had a whole lot. Our jury was 8 men and 4 women, which was interesting because the defense used 4 of their 5 strikes on women. So they had very clearly in their, focus groups or whatever they had done, that it had been made obvious to them that men were going to judge James more harshly than women were. And to be honest, our focus groups had said the same thing. So they managed to kind of get a jury that they really liked. And we had a lot of guys that were blue collar workers, some guys that had worked with heavy machinery, a couple of guys that were mechanics. And so a lot of people that they thought would come down on the side of, you know what, if you asked me to do something dangerous, I would have said no. And I think what they didn't understand was that that same group had been in a position where they had been rushed and they had been put under pressure and they had been forced either into situations that were dangerous or had been forced to do things that were dangerous. And so once it became bigger than just trying to please the movie director, but it became about those kinds of safety issues, then I think it was easier for those jurors to say he was put in a bad position and he never should have been at that point on the hill at that time making that choice. That should have been taken care of him way before he got there.
Absolutely. And I was going to say, when you told me about the blue collar workers, people would work with heavy machinery, that concept of defensive attribution, that wouldn't, I wouldn't have done that. That wouldn't have happened to me because you can't live life, realizing how random things are and how easily it is to get hurt and have your life ruined. And so I guess that's the way you overcame that that tendency towards defensive attribution.
That's what we tried to do. And I mean, we lost, we did 3 focus groups on the case and we basically lost all 3 of them. We did one, it was a weird circumstance where we picked the jury and then we had 2 weeks before we started trial. And after we picked the jury, the night we picked it, I mean, I didn't sleep a wink that night because I wasn't crazy about the jury we got. And so we did a focus group and tried to match the demographics as much as we could. I mean, it's sort of inexact. And I think the jury was assigning huge percentages of fault to James, and relatively small percentages to the movie companies. And so that, the defensive attribution was exactly the reason that they were doing that. And I think what we tried to change was broadening it out a little bit, I think was important. And I think it was also important for a while, we were scared of James was a specialist. And so the focus groups, the more we talked about him being a specialist, talked about him being the expert, the more they were inclined to blame him. And so I really wanted to figure out how we wrap our arms around that because we couldn't get away from it. And I think we would have been foolish to try to make him something less of an expert. And so what we really did that we didn't do in any of the focus groups was we talked about, as a specialist, what did he expect when he showed up on set? Not what was he supposed to do as a specialist, but he had worked on hundreds of movies. And so what he knew was that if he was going to be first up, he was given the opportunity to scout it the day before. If it was dangerous terrain, he was sent pictures of it. He was allowed the opportunity to preview the route himself. What he knew was that the people on set were supposed to mark the route for him. So it was really his specialty. We really turned that on them as much as we could to show, as a specialist, here's what was expected of the other people on set. And nothing that they did beforehand gave him any indication that those things wouldn't already be done. So that was, I think, something that was really important in terms of turning the perspective on James as a specialist and turning that focus on the defendants and what they failed to do for him. And now all of a sudden it's chaos. And he's doing the very best he can at that moment.
That's brilliant. So tell me about the trial.
The trial, the other thing that we really tried to do from beginning to end, and it's one of those things that all of us know on a comparative fault case. I mean, it was a comparative fault case. It was to own that and really own it. I sort of joke about there's kind of owning it, like saying something like, well, we don't think he did anything wrong, but if you do, it's okay. You can give him some percentage. That's not owning anything, right? So one of the things that we did from voir dire, opening, all the way through the trial was tell the jury, this is a comparative fault case. James Razzo, at the moment that he was sitting at the bottom of the hill, could have said no. So at the end of this case, we're going to ask you to assign somewhere between 20 and 25% to Mr. Razzo. And the reason we're going to ask you to do that is because he never should have been there at that moment, at that hill, at that time. And so early on, we wanted to take that defense away. And we knew that the damages, if we got there, the percentage we would be giving up would be insignificant in the scheme of the case. The danger was far more losing the employment issue and losing comparative fault in a huge way. And so it allowed us to try the case in such an honest way with the jury because we weren't running away from anything ever. But we were, by doing that, now all the focus is on the defendants and their conduct. So the trial came in. It came in really well. It was a weird trial because in New Mexico, we're still under COVID protocols. So we've still got masks on in the courtroom. Wow. So beginning to end, every witness, every time you're talking, every juror, you're in masks. The jury is still spread out. Some of them are in the gallery, some of them are in the jury box. And because of that, I think we probably maybe a third of the witnesses were via Zoom. And then 2/3 of them were live. And that's also just kind of a function because it's a movie set. Once the movie shoot was over, everybody was gone. Nobody was really from New Mexico. But the good part was the case, it came in really, really clean. I think the defendant's witnesses came across as very, I think the perception of the movie industry out here is that they come to New Mexico, they come to do the filming, they look down on everybody that's here and, take the money, take the tax incentives, take all that kind of stuff, and then they're shipped back to California. And they don't really care about anybody that's out here. And some of that came through in the testimony. I mean, the local guy was the one that nobody was listening to, who was telling him to go the safe way. I think that bothered people.
Yeah.
One of the witnesses was one of the corporate witnesses was very, very, she was on Zoom and was really confrontational. I mean, from the word go. And was also insurance, workers' comp, some of those kind of things were not supposed to be part of the trial. And she somehow dropped that in her testimony like 4 times. And it really offended the judge, first of all. And I think it was extremely ineffective. She played into all of the negative stereotypes. And so, from that standpoint, and our client, James, I mean, he did wonderful in terms of his testimony, and so did his wife. I mean, I really felt like they were able to bring to light how life-changing this has been. The jury was able to see that in such a genuine way that we didn't have to present, hours and hours of testimony about the effects on his and his wife's life. They were able to just see that through their testimony. And I thought that was a real, something we really tried to do was just present it in an authentic way through the fact witness testimony, more so than expert testimony. We had a life care planner. We had his primary care doctor testified, and then his psychologist testified. And it was really heartfelt. I mean, you could tell how much his primary care doctor respected him, how hard he's been trying since day one to get back to as much of his life as he can. And his psychologist was just lights out. She was so good.
That's awesome. So what did you ask for, and how did you come up with the number you asked for?
Yeah, so the economic damages between the life care plan, his lost wage life care plan was $5 million. Lost wages was like $3.5 million. He's never going to be able to work again. So this is all, present value stuff. Pat medicals were like $1.5 million. And so you put all the economic damages together, it was like 11 million. And so what I did was I asked the jury for 3 to 4 times. And what I meant to say and what I said were 2 different things. So what I said was 3 to 4 times medicals.
Oh, wow.
What I meant to say was 3 to 4 times economic damages. And the reason I mentioned that is because when we interviewed some of the jurors afterwards, and so 3 to 4 times would have been like 33 million in terms of compensatory damages for James. They wound up giving 600,000 for James. And the way that they got there was they took the path medicals and the life care plan, multiplied that by 3, and then added in the lost wages. So that's how they got there. So who knows what would have happened if I had said economics instead of medicals, but but anyway, that's how they got there on that. On Susan's consortium claim, I don't bring consortium claims in lots of cases because I think it just detracts from the damages of the plaintiff. And in most cases, I don't bring medicals either, but here they were so significant that it made sense to do that. But on Susan's claim, I really wanted to honor her claim. I didn't want to short sell it ever because in her testimony and in James' testimony, she has been such a rock for him and for that family. I mean, it's been almost 6 years since this happened. And, the amount, his life has been consumed with medical appointments. There's also, cognitive and serious emotional damages to him because of this. And she has been right there for him every single moment of every single day. And their family, they have 2 kids. And so the way that we presented the consortium claim was really not earth shattering or anything, but I had James talk about how much this has affected her. And I had him talk about his own self very, very little, to be honest. And then the reverse of that, I had Susan really carry it in terms of talking about how it's affected him. And so to me, what I talked to the jury about when I was talking in damages for Susan was I left it to them. I didn't give them a number for her, but I told them how significant it was. And I said, it's in the millions, but I want you, I leave it to your discretion. And they came up with 6 million for the consortium claim. And so that's how we wound up presenting that claim. And I was really, I was so pleased that they honored her claim too.
Yeah.
That the jury did. And I thought that was, I mean, just for that case, it was the right way to do it.
Yep.
And then on punitive damages, it was even, so what we wound up talking about there was the state of New Mexico pays movie companies to come film here. So they call them tax incentives, but when you peel it away, it's not a tax incentive. They write them a check. So the state of New Mexico wrote a check to the movie companies for $9 million for filming this movie in New Mexico. And so what I talked about was that they needed to pay that money back plus interest. And so I think what I said was for Black Label Media, the 9 million, it's been 5 years since, and they need to pay that back with interest, and it needs to be at least 15 million on the punitive damages. And then I said for no exit, we leave it to your discretion, but it needs to be very significant so that they know when they come to New Mexico. I think what I said was they don't only bring cameras, but they also bring safety. And that this verdict has to make sure that they know that, and that other movie companies that are going to come to New Mexico also know, or that other companies that film in New Mexico also know that. And so what the jury wound up doing was for Black Label Media, which was really the parent company, but also heavily involved in all aspects of the film. They weren't just a de facto parent company. It wasn't a parent subsidiary case. It was a direct liability case against them. They gave them 3 times the amount that they had been paid, so 27 million, and then they gave 9 million against the no exit company on punitives. So they very much took that number that we had talked about. They just thought it needed to be more significant than what I had told them.
Well, I'm glad you weren't persuasive enough.
Exactly, right? Glad we opened that door for them a little bit.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
And tell me about, at least twice there, you just gave them the discretion without giving them a number. And I've heard different thoughts on that. What was your rationale behind just saying, I trust you rather than giving them a specific number?
I've heard different thoughts on it, and I've had different thoughts. I mean, in almost every single trial, I think I did that. It's funny, we're all sort of a creation of our own past experiences. And in one other trial, I think I didn't give them a number in closing, and it wasn't a very good result. I mean, we still won the case, and it was still something. And I was walking back to my car, and I happened to be walking next to one of the jurors. And I was sort of talking to him as we were going by, and he was saying, we really needed some guidance on that. We really felt like we didn't know what we were supposed to do. And I think if we had, maybe it would have been bigger. So that was, so after that one, of course, for the next however many trials, I made sure to always, always give them a number and a reason for the number. And I still think that's true. So the reason I was comfortable doing that here was I very clearly gave a number and a rationale for the number for the main damage in the case, which was the compensatory damages for James. And that number was significant. That number that I asked for was 32 million. I didn't want to short sell the consortium claim. And I had done that in some of the other focus groups. Some jurors kind of thought the consortium claim was like at least half of what the damage to him had been. And so I felt like telling them how significant it was, presenting it the way that we had, and talking about it and telling them it's in the millions, at least gave them the freedom and the trust. I think the key on getting a big verdict, or really any verdict, is you've got to trust the jury. You've got to give them what they need, arm them with what they need to get a result that you think is what is justified, but trust them at the end of it. And so what I was trying to do was show them that we had trusted them from the beginning of the case, and we trusted them to come up with a number that was justified in this case. So it was kind of a mixed method, where I gave numbers on some stuff but didn't on others. And I think what that showed them was they had the freedom to choose what they wanted. Me telling them, for instance, that Black Label Media, me saying I think the punitives ought to be 15, it was just a suggestion. It wasn't a ceiling. And they knew that because I had given other things that were wide open and didn't tell them what to do. So when they thought it needed to be a whole lot more than that, they felt like they had been given the power to do that. So that was kind of the thinking on this case, was mixing it that way.
And how do they do on the percentages?
So the percentages were interesting. So what they did, and I told them in closing, I said, we told you in opening that we thought it would be between 20 and 25% for James Rouzo. I said, quite frankly, based on everything I've heard the last 5 days, I think that was probably too much, but I'm not going to back off of it. But I think it should be no more than 20. You may decide it's less. They ultimately assigned 19% to him. And I think what I said was 20% to James, 20% to No Exit, and 60% to Black Label Media. It ultimately came out as 62% for Black Label Media, 18